Good evening, Ms. Robson. Thank you for joining the Office of Open Government. Thank you for attending this Open Meetings Act training. Feel free to type in the chat, or since we're such a small group, you can raise your hand, interrupt, and ask a question. I'm Sheree DeBerry, attorney advisor with the Office of Open Government. We have in attendance Chief Counsel Johnny Barton. We have trial attorney Nick Weil. We have attorney advisor Anthony Skirbo. And we also have Ms. Kimberly Brown, who is our paralegal specialist with us today. So you have officially met the OOG staff. One second. Here we go. The Office of Open Government is a separate office within the Board of Ethics and Government Accountability, which we refer to as BETA. The OOG enforces the Open Meetings Act and its regulations. We have as our Director Nicole Allen, Chief Counsel Barton, myself, Attorney Advisor DeBerry, Trial Attorney Weil, Attorney Advisor Skirbo, and Paralegal Specialist Ms. Kimberly Brown. The Office of Open Government provides education as well as training on the open meetings laws and the District of Columbia Freedom of Information Acts. The primary mission of our office is to promote government openness as well as transparency. Open meetings laws are designed to give the public confidence in the decision-making process of members of a public body. Most meetings of a public body are required to be open to the public along with their decisions and records. A meeting is usually defined by its purpose and the number of participants. You ask yourself, is the purpose to perform public business? A social gathering is not considered a meeting. You can also ask yourself, do we have the correct number of members to conduct business? Do we have a quorum? Meetings are presumed to be open to the public, and the public must receive advance notice of the meetings. Advance notice includes the date of the meeting, the time of the meeting, the place, the location of the meeting, and as well as a draft agenda. A meeting is a gathering of a quorum of the members of a public body where the board members may consider, conduct, or advise on public business. Public business may include such things as gathering information, taking testimony, discussions, deliberations, recommendations, as well as voting. A meeting may be held in person, via telephone, via video conference, or other electronic means of communication. What is not considered a meeting? A chance or social gathering where no business is discussed. This is not considered a meeting. A press conference is not considered a meeting. And if a quorum has not been met, then the public body cannot conduct a meeting. Unless established by enabling legislation, a mayor's order, or regulations, a quorum is a simple majority, which is more than half. Email exchanges between members of a public body do not constitute a meeting. Subcommittee meetings are also not considered meetings under the Open Meetings Act. We have to be careful with subcommittee meetings. If the number of members constitute a quorum, you have to adhere to the Open Meetings Act. Who must adhere to the Open Meetings Act? Public bodies. And who are considered public bodies? Local school advisory teams are public bodies. Government councils, which include the Council of the District of Columbia. Boards and commissions. Board of directors. Advisory boards that take official action by vote of its members, as well as board of trustees of public charter schools. Who are not considered public bodies, that would be a district agency is not a public body, the mayor's cabinet, advisory neighborhood commissions are not public bodies, District of Columbia courts, as well as professional staff of public bodies, and that's outside the presence of a quorum. What is an open meeting? A meeting is open if the public is permitted to be physically present. If the news media is permitted to be physically present, a meeting is considered to be open. Or if a meeting is televised, it's considered open. A public body's meeting must be open to the public unless the OMA permits closure. Notice. When a meeting is scheduled, a public body must give notice. Public bodies must give as much notice as possible, but notice must be given 48 hours or 2 business days before each meeting, whichever is greater. Notice must be physically posted in the school, the office, or a place readily accessible to the public. Notice must be posted along with the proposed agenda on the LSATs website or the district government's website, which is called the Central Meeting Calendar, and it can be found at www.open-dc.gov. Local school advisory teams must obtain an email address that combines the name of the LSAT school and the acronym LSAT to conduct all official business. And LSATs must timely post upcoming meetings and an annual schedule of their meetings. The physical posting requirement that I just stated earlier shall not apply during the period from March 11, 2020 through December 31st, 2023. This posting requirement is currently waived due to the public health emergency. So that's a requirement that public bodies do not have to concern themselves with right now. Notice must include the time of the meeting, the date of the meeting, the location of the meeting, be it virtual or in person, and the proposed agenda. Notice must also include the following statement. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. This statement must be included at the end of all draft and final meeting agendas. Next, we'll discuss closed meetings. Notice must also state whether your public body will enter a closed meeting. Notice must include the OMA citation and the justification for the closure. There may be a court order or statute that mandates closure. It's justification for the public body to close the meeting. Closures may be to discuss negotiations such as a particular contract. Meetings may be closed to preserve the attorney-client privilege or obtain legal advice. Meetings may be closed for discussions of trade secrets and personnel matters, or matters involving a student's personal information. Other justifications for closure: evaluations by eligible chartering authorities, trainings for staff, public body staff, board members, collective bargaining negotiations. A meeting may be closed to discuss preparation of grading techniques or for tests, deliberations in an adjudicative action. Public safety issues would be a justification, as well as plans or to discuss an investigation. So these are justifications that you can use to close a meeting, and these justifications have to be listed on the agenda. There is a protocol on entering closed meetings. The presiding officer will open the public meeting and establish a quorum. The public body will conduct business in the open meeting. After that is concluded, the presiding officer will move to enter into a closed session. The motion must include reference to the OMA citation that justifies the closure, and those are the justifications that I just went over. Another member must second the motion. Then the presiding member will then take a roll call vote, and if the motion passes, enter into a closed session. You're only able to discuss matters that are referenced on the agenda. That's why it's so important, whatever justification you use, it may be one or two, those are the only items that may be discussed in that closed session. And you have to record all open and all closed sessions. They all have to be recorded. After the closed meeting concludes, the presiding officer will then reopen the public meeting and, where appropriate, report publicly any official action taken in closure and then adjourn the meeting. And that is the closed meeting protocol. As I said before, all open and closed meetings should be recorded. Recordings may be via audio or video recording, or you can complete detailed meeting minutes, and you may also use a transcriber. And you must ensure that there are no copyright restrictions with posting the minutes. So that's something you have to discuss with the transcriber's company. Publication requirements. Draft detailed meeting minutes must be publicly available no later than 3 business days after a meeting takes place. And you must note at the top of that document that the detailed meeting minutes will be posted to the website on the next meeting date. Audio recordings, video recordings, and transcripts are all considered copies of the full record, and they must be available no later than 7 business days after the meeting occurs. Record maintenance is extremely important. The district requires preservation of electronic meeting records as well as written meeting minutes. All meeting records must be preserved for a minimum of 5 years. So you cannot destroy the records for at least a minimum of 5 years. Electronic meetings, a public body can meet via video conference, phone conference, or other electronic means, and that's only if they make a reasonable arrangements to accommodate the public's right to attend. All meetings have to be recorded, open and closed. The votes have to be taken by roll call, and all provisions of the Open Meetings Act have to be adhered to in order to be compliant. Public comment, public bodies may allow for public comment. A public body may have enabling legislation and bylaws that mandate a period for public comment, or a public body may allow public comment absent a mandate to do so. When we're dealing with the local school advisory school teams, their guidelines suggest that each individual team may want to set aside a time for public comment. So that would be up to each individual team whether they would allow public comment or not. Cancellations, public body meetings may be canceled. A meeting cancellation is considered a change in schedule, and the public should be notified of the cancellation. The OMA requires as much notice as possible, but not less than 48 hours or 2 business days, whichever is greater. You must establish a record that the meeting is going to be canceled. The meeting notice has to state that the meeting is canceled, and this is to ensure the public that you are not meeting in secret. This is to justify we did not have a secret meeting. It was actually legitimately canceled. Emergency meetings. A public body may meet in case of an emergency. The presiding officer must clearly state the nature of the emergency. The presiding officer must open the meeting with the statement explaining the subject of the meeting and also explain how the public was provided notice. This notice must be given to the public at the same time that it's given to the public body where you're dealing with an emergency meeting. We want to be clear that to differentiate the difference between an emergency meeting and a special meeting. Emergency meetings are not special meetings. Special meetings occur outside of the public body's regular meeting schedule. If you have, for example, if you have 10 meetings scheduled for the year and an issue arises where you need to meet outside of the regularly scheduled meetings, that meeting would be considered a special meeting. And notice for a special meeting is the same as that of a regular meeting. It's 48 hours or 2 business days prior to the meeting. Emergency meetings usually involve urgent matters where advance notice is not possible. Emergency meetings usually consist of matters that pose an immediate threat to health, safety, welfare, or regarding destruction of property. The Office of Open Government has a complaint process. An aggrieved party may complain to our office for relief if a meeting may have been conducted in violation of the Open Meetings Act. The complainant may refer to past meetings, or the complainant may refer to meetings that are scheduled to occur. The complainant may submit the complaint in person, online, via email, or by mail. Director Allen may also seek to resolve the dispute through the conciliation process. She may dismiss the complaint, issue an advisory opinion, or take any other steps that are permitted by the Open Meetings Act and the Open Meetings Act regulations. Enforcement. The Office of Open Government has the authority to bring a lawsuit in the Superior Court of the District of Columbia for injunctive relief for any violation of the OMA before or after the meeting takes place. The court may order an appropriate remedy, such as the court may require additional forms of notice, they may postpone a meeting, or they may declare action taken at a meeting to be void. So there are a number of things that can happen if you violate the Open Meetings Act. Here's a quick summary of what has been covered so far. A quorum triggers a meeting. If there is no quorum, there's no formal action that can be taken. You're required to give the public notice, 48 hours or 2 business days notice before a meeting occurs. You are to physically post the notice and to post the notice on the website. And as I said earlier, the physical posting requirement has been waived until December 31st, 2023, and that's due to the public health emergency. Your notice should include the time of the meeting, the date of the meeting, location, via virtual or in person. It should include a draft agenda, and it should also include the citation to the OMA for the closed session if you intend to enter into a closed session. If that citation is not included, you're not allowed to enter into a closed session. You must record all open and closed sessions of the meeting, and recordings of the public meetings must be available to the public without the need for a FOIA request. So no one needs to go through the formal Freedom of Information Act process to obtain records from a public body. Draft meeting minutes should be posted within 3 days, and detailed meeting minutes should be posted on the next meeting date. So we have everyone's contact information listed here. Please feel free to reach out to our office. We're here to assist and help. So all local school advisory teams will continue to be OMA compliant. And Ms. Robinson, feel free to reach out to us for any questions or any assistance that you feel that we could be to the local school advisory teams. I thank you for attending this training. And if you have any questions, we're here to answer them. Are you on mute again? Let's see. Hold on 1 second. Oh, we have 2 attendees. Thanks for joining us. I will take you off mute.
Hi, thank you, Miss Berry. Miss Franklin, I'm just curious, which school community are you from?
I'm trying to get her off of mute. Okay, here we go. She should be off. Hold
Yeah,
on.
it took the button a second for me to allow me to unmute.
Miss Franklin, you're off mute.
Oh, Jenny,
Hi.
wonderful, wonderful.
Hi, everyone. I'm from the LSAT at Janney Elementary School. I'm the staff representative, one of the union reps for the partner. Well, we call them partner teachers, but DCPS called them educational aides. So I've been on the LSAT as long as I've been at Janney School, almost 30 years.
Awesome. So that means you were a part of the local school restructuring team like I was. So I understand.
Yeah, I was actually the chair at Blow Elementary School once upon a time, the LSRT. Yes.
Okay, got it. Thank you for joining us.
Sure.
Hopefully you'll be able to encourage other members of your LSAT to attend. I do think this information is extremely helpful and, can just help all LSATs to become more efficient and, of course, more compliant with the Open Meetings Act.
Yes, I will relay the information that I received tonight. I apologize for my tardiness. I'm coming from Tinley Town to Southeast, so I was a little tardy, but it was very informative, and it's information that we can actually use during our meeting process. But there are 2 other sessions, correct?
Yes.
Yes, we have a session on March 22nd, and that's at 6 p.m. as well. And we have a session on March 25th. It's a Saturday, and that's at 12 noon. And the session on March 22nd includes a portion on parliamentary procedure.
Yeah.
I don't know where you popped in, Ms. Franklin, but do you have any questions, or would you like me to send you the
Yes, if
slides?
you could send me the PowerPoint, the deck, and I'll share it with our 2 co-chairs and other members to make sure we're following the proper procedures when we do have our meetings.
Do I have your email address?
Let me put it in the chat.
Okay. Ms. Robinson, thank you again for attending. Look forward to seeing you on the next 2 meeting dates. And Chief Counsel Barton, I don't know if you have any comments or would like to say anything.
Just clarify. Sometimes there's some confusion as to when meeting minutes, written meeting minutes versus a recording necessary under the Act. As Sheree stated, all meetings have to be recorded by electronic means. However, if there's some sort of technological failure and you're unable to record a meeting, then you're going to take the detailed meeting minutes and you're going to post those in lieu of the recording. In the past, and I'm just going from my experience, a lot of other bodies have had some concern and some confusion about when they are to do what. Just want to make sure that that's clear. And thank you so much.
Thank you. And you all have our contact information. Feel free to reach out, and hopefully we'll see you on March 22nd.
Yes. Thank you.
Thanks. Have a good night.
You too.